Good evening, ladies and gentlemen. I know it has been a long day for all of you, and I just don't plan to keep you long enough. And as you have already heard the organizers say that my co-panelist, has not been able to make it, and so there is something like, in a lawyer's language, force majeure situation, so I have to run the roost for this panel. As you are aware, you've seen the agenda. The topic is, the evolving role of IP in a pharma M&A, which is, pharma mergers and acquisitions. Just before I start with the presentation, a little brief on, from where I come. I'm from India. I work in an Indian multinational company called Wockhardt. It's in the pharmaceutical and healthcare space, and it's in the top league in India. We have business over all the continents. In all the continents, over 70 countries. We are primarily a generic pharma company. I think, as you have heard during the course of the day, whenever pharma is being spoken of, there are basically two types of companies. One is the originator, or what we call the innovator companies, and the other one is the generic company. Innovator companies, as you all know, they are in the patent space. They protect their patents, and somebody mentioned evergreening. A lot of evergreening, and there have been judgments evolving on evergreening, not only in the US and the European Union, but of course across the globe. And a lot of contentious issues around, patent immortality, as I quote it, evergreening of patents, compulsory licensing in developing countries, and compulsory licensing, as I mentioned, it's like a marriage between two people, two non-consenting people, and it's a forced marriage. So there are a lot of issues on compulsory licensing, and so therefore when you have an M&A transaction in the pharma space, the intellectual property plays a big role. And before I just start with that, let me just take you through the global downturn we all had in, I think, around 2008, 2009. And if you would have taken an account of the balance sheets of various companies, not only pharma but even other companies, I think the balance sheets eroded by more than 80%. But what was that 20% which remained in the company's balance sheet? It was the intellectual property. So, as you can see, the famous words, "pen is mightier than the sword," were realized their full potential during the economic slowdown. While all the tangible assets were fast losing their value, and money was a scarce commodity, only the company's intellect in people power stood the test of time. So that's the importance of the intellectual property. And we have been seeing during the course of the day the trends which have been evolving in the intellectual property, and going forward you won't be surprised that the concentration of the economic power would be on the innovations, the ideations, and the intellectual property, and the balance sheets would be valued more than 90% when it comes to the intellectual property. The intellectual property and its importance grew manifold, and the world was sewn together by nothing but the mind. Brand licensing, patenting, patent wars, and mergers and acquisitions, slump sales, etc., meditated only to gain the IP, flooded and the global scenario. And this was actually the situation in the global downturn. It was the intellectual property which actually helped a lot of companies to salvage themselves, to realize values from, I would say, maverick spheres, unconventional spheres, because we moved away from tangible to intangible assets. And the role of the IP in pharma as well as in other companies have only grown since then. Now, when you talk of an M&A, first, what are the basics? Competitors and product pipeline. Now, if a particular pharma company wants to enter into a major transaction, now there are various structures. As we go through the presentation, you'll see the various structures for these transactions. What does it need to see? First, I think it needs to see the market. who is there in the market existing, who will be there future, and accordingly it will actually strategically decide whether I should enter this particular region, this particular jurisdiction in terms of the legal jurisdiction, or should I wait? What are the risk factors? So it's very important to know the competitors and what are the product pipeline you have. That is, pharma company who wants to enter into the transaction. What is the product pipeline of the competitors existing in that geographical territory as well as the legal jurisdiction? We'll come to the legal jurisdiction a little later. Next, know your partner. We've been speaking about Pfizer's, here. We've been speaking about other multinational companies. Now, if you're dealing with a company like Pfizer, you should know Pfizer well, not only, in terms of, what deals they have done, but how does Pfizer work? How does it psychologically work? How does it, what has been its plans? What are its plans in the future? How does it deal with its partners in various transactions? Are they happy partners? Do their joint ventures last long or they exit? It's very important to study your partner before you enter into any transaction, because unless you know your partner well, a lawyer will give you the document, but ultimately it's the business who has to run through that document for a period of 5 years or 15 years, or it could be a permanent transaction. So you really need to know who is your partner. Next, structuring the transaction. That's very important, your motive. Would you want, money into the company? Would you want a joint venture? Would you want an asset sale? So there are various kinds of structures. It all depends, what you're looking for and how much you want to expose in a particular segment. Let's say you want to enter into a respiratory segment. You should know that whether you want to acquire a small company or you would want to do a distribution agreement. You want to maintain a principal-to-principal structure. So, this is very important when you are doing an M&A. How do you structure your transactions? And of course, issues in IP. Pharma without IP is just unthinkable. It's like, your body without your heart and brain. So, it's the hardcore thing in a pharma. So all the issues related to IP, which, we'll go when we go through the due diligence slides, it's very important. Exits and deal size. Exits and deal size are also equally important. Deal size, because how much is your promoter investing in the transaction. Basis that how complicated your transaction covenants would be, your warranties would be. So that's very important. Also your term. And whether that term and the renewals, that is very important when it comes to deal size, because at the end of the day, it's hard-earned money going into a transaction. However rich is the promoter, or however, a baseline promoter is, it's very, very important to know that how the money flows right from the beginning till the end of the transaction. And exits. If I'm in trouble, because, we lawyers try to make foolproof documents, but every time it may not be very happy situation. So you should know your exits, and you should know the cost of the exits and who is exiting. If I exit, I should know what is my cost. If my partner is existing in the transaction, I should know his cost and also what will be my future cost. So it's very important to know the exits in a transaction. So these are some basics before you get into detailing. Every M&A has an objective, as I have been saying, cost. I have explained market, hurdles. Now, hurdles could be various different types of hurdles in a transaction. It could be litigation. It could be compliance. It could be GMP, which is, in a pharma company, GMP, good manufacturing practices, good clinical practices, good distribution and supply practices. These are very important. So, these could be hurdles. And basically, that is the health which needs to be checked before you really pen down the document. And that is very critical element of the due diligence. once you know the litigation patterns, the infringement patterns, the how the segments of products enter into the market by the company, how they exit, these will tell you whether the company is landing into more hurdles, has more hurdles to face or not. So that's another objective, and of course exit strategies, which I have already discussed. Now, due diligence. No transaction can be complete without due diligence. And ladies and gentlemen, please believe me, no due diligence can be perfect. So, if someone says, this is a perfect due diligence and I've covered everything in that, well, I think that's a dream. Due diligence will always have some shortcomings or the other, because at the end of the day, you are dealing with two sets of things in a pharma company. One, of course, is the IP, and second, of course, are the people and the uncertainties of law. In the pharma area, there are two words which are very, very active or prevalent: affordability and accessibility. And that is the bone of contention of the originator pharma companies and the generics. So how do you get the right mix of affordability and accessibility is very, very important when you are doing a due diligence, because at the end of the day, you don't want your transaction to go down the line and fail, maybe fail after 5 years, 6 years. You don't want to fail. And there have been very, very big failures in the pharma space. And I will quote you a few, back from my country, and we'll see how they have failed. Now, in due diligence, issues like jurisdiction. Now, supposing you're dealing with a jurisdiction like somebody mentioned China, you're dealing with a jurisdiction like India, you're dealing with jurisdictions in Africa. I have friends from Africa here. They are very starkly different from the jurisdictional issues you have in developed countries like the US, the European Union, Australia, New Zealand, Far East, some of the Far East countries like Hong Kong, Singapore. So when you have to cross-marry a transaction which covers products, from all these jurisdictions, is very, very important. The jurisdiction issues in each of the countries. Because unless you know each of the jurisdiction issues, or at least try to know, what are the trending legal issues over there. Like, for instance, if it is an antitrust related issue, the antitrust related issues are quite different in the US and in India. So if there is a cross marriage of transaction of a US party on one hand and an Indian party or a Chinese party on the other hand, it's very important to know the differentiator in the jurisdiction issues, because otherwise, the marriage in the documentation would not be it would not be good, or it would not give the best of results. Patent litigation. Very, very important to study patent litigation patterns in a deal. Now, if, let us say, an originator pharma company is entering into a supply and distribution deal with a generic pharma for a particular jurisdiction in, let's say, Africa or Asia, very important to see that generic pharma company, how does it trend in litigations? Now, normally, the generic pharma would, many of them, I would say, do para 4 filings and land up with the Hatch-Waxman litigation. Now, what is the trending? Now, are they the types who always, take the innovator to the court? Now, if that's the trend, when you're doing the due diligence in the patent litigation area, would you be comfortable to enter into a contract with such a competitor, or with such a person who in future in other segments could pose a problem to you? Now, it's a very, very interesting point which a lot of pharma companies consider and a lot of pharma companies don't consider, I have seen. For instance, if like as I'm explaining, a distribution agreement between an originator company and a generic company, a lot of companies, originator companies, take a call and they do enter. But then, the same generic company, they go and they have Hatch-Waxman or powerful litigations in the US where they are fighting their same counterparty. So you should know, whether you can match your corporate policy and have a transaction with that generic pharma company. So patent litigation pattern, how important it is to your organization from a policy perspective, and of course, minutely from a transaction perspective, how important it is very important. It's an important due diligence issue. Exit strategies. Now, let us say there's a generic company, a role reversal. A generic company is acquiring an originator company. It wants to enter into the prescription area. Very important to see that, of course, the validity of the patent, quality-wise, the period validity, very important. And if the period, because of, certain price considerations, sometimes the period of the validity is not, the period is not more. Let's say, you're at the fag end of the patent period and you just have another 2 to 3 years left and you're getting a good deal. You're getting a good deal in acquiring this originator company for a couple of reasons. One, you're getting a 2 to 3 year period of price maximization. Two, maybe you're getting a distribution channel network in that jurisdiction. So, you could, channel flush your generic products. That could be a second consideration. Third consideration, as I have mentioned, could be exit strategies. Is the exit strategy of that originator company very strong? If it is very strong, then you really know that you could maintain your business tempo at a particular level going forward, even after the patent validity period has expired. What you do is, you know the exit strategies, you know how many generics will enter, and whether that product is very complex, whether a generic can actually manufacture that product. So that's where, a patent exit strategy is very important due diligence issue. And there have been companies I've seen where, generic companies have purchased originator companies and have failed miserably to the extent, the patent exit strategy of that acquiring originator company failed so miserably that, the company had to go insolvent. It had to be wound up. So very important, in a pharma acquisition is, studying the patent exit strategies. Of course, enforcements of your IP. You have, whether it's a generic IP, that's what we call is the brand or the trademarks, or your patent. Are you dealing with a jurisdiction or with a court regime which is helping you, or it is helping a generic market player? That's again very important, depending on which side of the table you are, a generic player or an originator player. It's very important to know the enforcement regime, because once you know the enforcement regime, you will know after the transaction if you have an issue tomorrow. In India, we have a concept which is called forum shopping. It's there in, some of the developing nations of Asia and Africa, where, certain enforcement jurisdictions are very, very active. And, there are a lot of litigators over there. Now, when you are dealing with some product acquisition with a pharma company, you should know that, which enforcement jurisdiction you're working on. And if you really know, then you know what is the strife regime of the the segment of products which you're acquiring. So, enforcement regime is very, very important due diligence issue. And of course, today, data security policies and confidentiality agreements are very, very important. We've been speaking about artificial intelligence. I think I was very much inspired by both the sessions which I attended post-lunch. today data security of your IP is so important. And IP is just not IP, it's the employee's brain behind the IP and how you protect the organization with those contracts. How you do proper employee assignments, how your employee contracts are drafted vis-a-vis, the innovations. So they are absolutely separate set of contracts, and due diligence of those contracts are very important, because tomorrow you just don't want to be sitting on a situation where actually you don't have a patent and it is owned by, somebody else. So the transition of the innovation from the group and the employees to the organization, and how tight it is and how secure it is a very important due diligence issue today. Also, a lot of IP sits in confidentialities and trade secrets. Developed nations have trade secret laws. Developing nations, most of them don't have trade secret laws. And I think more than 50% of the IP of an organization sits in such confidentiality information. So it is very important how you protect, how the laws in those jurisdictions react to such breaches, confidentiality breaches or trade secret breaches, the criminal laws, the civil laws. So these are very important due diligence factors. And of course, we have spoken about antitrust. And nowadays, very basic in any M&A, not only pharma, is the corruption and the counterfeit positions. This is something which is, it's already there in the US and the European Union, but valuation of IP in our balance sheets under specific norms, it has come about a couple of years back in India, and it is coming in a lot of Asian and African nations, is how do you actually give the right value of your intellectual property in the balance sheet. Most of the time in the developing nations, this had gone missed. So a lot of
everywhere, not just in developing.
but I think I appreciate, ma'am, but it was in a very, very serious and pathetic situation, in Asia and Africa. But I know in India for sure, we have accounting norms today, and we have to value the IP properly, and there are proper audits done on these valuations. There are tax audits done on these valuations, and it's very important today as a due diligence issue, if especially you're doing cross-border transactions across jurisdictions, or even if you're doing a local transaction, whether what the counterparty is claiming in terms of the value and how it has been actually valued by experts in the balance sheet, whether there's a match. And the third angle is whether this IP is actually registered or recognized, because some of the IPs are not registerable, but they're definitely recognizable. So, the due diligence should cover all the threefold areas. As I said, disclosure of IP, valuations, IP backed by revenues. Another important thing in due diligence issues are your R&D work and your clinical trials, which have actually led to the patenting. So, it's a very thorough work of due diligence to, see right from the alphabet A to the alphabet Z. So you complete the entire process, and you reasonably make sure that yes, the processes have been followed, and you come to a due diligence result in terms of the quality of that patent or the IP. Now, if you're dealing only with, this is a slide which deals with generics only, an M&A of only generics. Now, what are very typical things you would do? Let's say a generic was a Mylan versus a Mylan and a Teva entering into a generic M&A, or let's say Walk Hard and Sandoz. Sandoz is another generic company. It's a generic company of same group as Novartis. So if it's a generic versus generic, then some of these things is, how do you value the generic IP they have? Because, they are the non-proprietary products. So that's one due diligence valuation. As ma'am said, the norms are different for different countries. The different advisors do the due diligence in different ways. So, there are no set procedures. So, it's very tough to actually do a due diligence valuation of a generic product. And the uncertainties are more because, the competition is huge. It's free for all. It's like a laissez-faire. Another thing is like, what is your competition? Again, how many players are there? Now, if I, as Wockhardt, I'm going to acquire, let us say, a respiratory segment of Teva in an area, let's say, Central Europe, how many more people can enter? And past history, people who have entered, how many of them have survived? That's very important, when you're dealing in the generics. Second thing is product mix, in generics, normally, it's always advisable to have it should not be a one product transaction. The risks are very high because you never know when you can be slated out of the market. So it's always better to have, some upsides and downsides and have a product mix in your transaction. So you may have a product which is very popular. You may have a product which is, just, it's futuristic. You may have a product which has got price controls, there are price controls. It's very common in the developing countries, like, as I said, accessibility and affordability. The governments come out with huge price control. And you may have totally a new product, maybe off-patented, but it's such a complex product, or a product under data exclusivity. So it's always better in a due diligence issue to have a product mix if you are, dealing with generic to generic. Disease pattern, very important. Now, let's say if you want to do an M&A transaction of an antibacterial product in Northern Europe, I would say it would fail because bacteria is not a segment in Northern Europe. It doesn't grow. You'll have a a virus condition in Northern Europe. So you may not succeed even if, somebody gives you a very, very lucrative value for a company which has. You could still go for it if you have plans for bringing that product out of Northern Europe to some developing nation, because that's the place where bacteria thrives. The climate is like that. So it's very important to know your disease pattern. And of course, the product mix, in your country, what are the products you have, and internationally, what products you have in a segment and cross segments. Litigation analysis, as I have already covered, very important to, study not only the existing litigations the party is having, but also litigation in that field. Like if there are Hatch-Waxman litigation in an anti-infective area, then please, the due diligence should study the entire set of litigation or as much as possible. AI helps in that. The other thing is, whether a particular jurisdiction helps in, giving parallel routes besides court, because court is very costly. I think today it's very costly all over the globe because you have discovery process and, it's... But if you have a jurisdiction which helps you to do an ADR, alternate dispute resolution, like a mediation. Today in India now, there is a recent amendment which says that before you get into an IP suit, you have to compulsory go for a mediation. So, you save a lot of costs. So, another thing of the, the due diligence is, how your, the court regime or the alternate dispute regime is there for those areas where you're looking for acquisitions. And, how government takes actions in terms of price controls or antitrust, the compliance issues in different countries. As I said, GMP, GDP, GCPs, your contracts which are under due diligence, how compliant they are. That's called third-party compliance. Your vendor diligence, your suppliers, So that's, again, a very important part of a pharma due diligence, And how strong your distribution network is, so that your products, they just don't get there's no break in the supply of the products. And of course, litigations, as I have said. Now, these are the different types of structures for an IP transactions. You have an asset sale, so you could have a brand sale. You could have equity structures where you infuse equity into a pharma company. And if the pharma company is it's a niche pharma company with some niche products, then definitely, the valuation of the IP has to be seen very minutely. Mixed bag, you could have both the structures. You could have a part asset sale or a part equity structure. Joint ventures, as I mentioned, there are various joint ventures between, originator or generic. Sometimes, very rarely, I've seen originator, but yes. Tech transfer, sometimes, you have companies who have been developing products, but for some reason, maybe it could be cost or it could be change in policy. They just don't want to continue in that particular segment of products. So, you do tech transfer and you license it out to another pharma company. So, tech transfer, licensings. Supply distribution, as we discussed, is another structure of a pharma M&A. And of course, there are some compulsory routes like, the debt route or the compulsory licensing route, the court routes. So, these are some of the typical structures in pharma M&A deals. And you must definitely take care when you finalize on your structure. You should take care of a tight documentation, very good due diligence. How much? Now, this is an interesting point of escrow and a holdback. You enter into a deal, are you going to give the full money? Let's say you enter into an asset sale, let's say Merck or Sandoz enters into an asset sale transaction with Pfizer. Pfizer wants to sell one particular brand and that product. Now, would Sandoz pay the full money up front, or would it hold back some money? Now, that's a result of how strong your due diligence is. If you see some issues and you reason out and negotiate with Pfizer, then definitely, you can have some escrow holdback, maybe some critical litigation. Maybe some change, you foresee a change in the government policy in the near future in terms of that product. So those are escrows and holdbacks. I think more than 75% of the transactions do have escrows and holdbacks. Indemnities should be strong. Transition after closure of the document. Transition from one company to the other company, it's beyond documentation. It's like, two sets of organization people coming together. So ensure that hiccups are as less as possible. Assess your agreement after signing. So one is, during signing is a negotiation and assessment before you sign the deal. One is assessment post signing the deal, that are you going to breach or is the counterparty going to breach? The probability. I think this is a new concept which companies have started now doing for sure, I know, for IP and pharma M&As. And of course, assessment of change of laws, which is, it's so frequent in our field. These are some of the important, pharma IP deals, and the biggest has been in 1999. It's a Pfizer deal. It's $111.8 billion. And, you have last year, which is, you have Takeda, you have Pamplona Capital Management, you have Bain Capital, you have Freshness Kabi, you have Swiss Pharma's giant Novartis, you have Bristol Myers, you have Roche, you have Great Group Corp, you have, you have all these companies. In India, of course, so far the biggest deal has been Sun Pharma and Ranbaxy. They are the two biggest. Ranbaxy, of course, doesn't exist anymore because acquired by Sun Pharma. Sun Pharma is the biggest generic pharma company in India, and I'm told it's the fifth biggest generic pharma company in the world. And the deal was about $4 billion, $3.8 billion deal. So that's the biggest in India so far. And in conclusion, ladies and gentlemen, vision is the way forward. That is what all strategies are screaming out loud. A company can thrive through the toughest of situations or turn around a bad situation through vision, innovation, and its people power. Thank you. Questions?
Very, very good talk. I really enjoyed it.
Thank you. Thank you, ma'am.
Really.
I enjoyed yours also.
Women power.
But I don't think we are outnumbered here.
No, but I wanted to poke here with your accounting stuff because this
Yes.
is a question which is very, very close to my heart for a long time now.
Yes.
Because all the IP valuation is off-book valuation because
Yes.
the accountants are not keen on appreciating the value of IP in the balance sheets. So we are essentially a big cost center with what we do, and there are a lot of inconsistencies. If you acquire or license IP, it appears. If it's internally held IP, it's not visible. It's not helping in any way. Is there anything more better story in India happening than what I know in Europe?
So
Have they changed accounting rules in India in any way
yes,
for IP?
they have. They have
Wow.
changed the accounting rules, and they have introduced a new accounting standard, and Mao Caro, as we call it, where you have to value your patents and your major galloping brands, as we call, by normally, as of today, it's done by the Big Four, or up to the standard of Big Four, and that has to be reflected in your balance sheet, including qualifiers like threatened litigations, commercial as well as IP litigations. So, this is something which is done. Plus, a tax audit compulsorily has to be done, especially if you're owning cross-border IPs. So, whether, you're tax compliant with the IPs which sit in, let's say, Indians have this, Indian companies, they love to hold their IP in Switzerland. Because of the tax treaty, of course. So, whether, there should not be any violation or breach of international laws. So, it's become very strict, and there has to be an auditor's note to that. So, this has started in India, and actually, a lot of my time, my colleague is here with me. It goes in this, and we are constantly, either it's an Ernst & Young or a Deloitte or a KPMG who's always, with us in terms of, how you are, what are the legal registrations, recognitions, protections, like, in developing nations. And as I think you only said, a lot of IP is not protected, like, for instance, trade secrets. A lot of them are not protected in many countries. There's no statute. But they have value. How to value them? There are no standard rules or norms. Today in patents, a lot of standard rules and norms have come. The Big Four have got their SOPs, how to value them and how to reflect them and disclose them in the balance sheets. But in terms of, other IP which sits, like for instance, brands which are off patents, the only way of valuation which they do is the revenue valuation, and they do a trending, with a discounted cash flow of the past 5 years with a future of 20 years, where this generic product would stand. And of course, there's a lot of, hypothesis and algorithms involved. But yes, some norms have been set forward. And I would say they're quite orthodox. So
Also the internally held IP, which is not associated with a direct commercial transaction, is recognized in India?
No.
No.
Not.
If it's in a license or a sale or something.
Oh, no, that's not yet been, there, I would say it is, there are no laws or standards to value them. No compulsory disclosures to be provided unless you are in a threatened litigation or a litigation stage. Then, of course, it gets into your notes to accounts. But otherwise, the internal IP in terms of licensing or, distributions and all, there has been no development on that front. Yes, yes, ma'am.
Sorry. Very interesting talk and very well delivered. Thank you. It was very clear. I had a quick question regarding forum shopping. You mentioned.
Yes.
So what is the sort of best forums and which forums are popular?
Actually, I shouldn't be speaking, which is the best forum because, well, under Indian law, it would be contempt of court. But I would say, in general, what is forum shopping and what a lot of companies resort to is, they feel a particular jurisdiction, territorial jurisdiction, the enforcement regime is, very friendly in terms of equitable reliefs or injunctive reliefs. So, and because the product is in all the jurisdictions and the law permits you that where your product is and there is an infringement, you could go to that court. So the court would not say no because you would be eligible to go to that court. But I think it's a very bad practice to do forum shopping. I am not here to advocate forum shopping, but it's an important thing to study in a due diligence if you're doing a trending due diligence of an IP. It's an important thing because you would then know, what type of a company you're dealing with. It could work both ways. You would like to deal with such a company because you would also want to avail of, I don't know whether I could say loopholes of law or good law, beneficial law. Or you could have a different policy mindset at all, whether I should enter into a transaction with such a counterparty.
Thank you. Is there any more questions? Anybody? No, I think they don't have any right now.
I think they just want to have
maybe
their
they will ask the questions during the coffee break.
Yeah, I'm there.
All right, so I would request Dr. Roya Gafili to present the memento to Debolina, please. Thanks.
I'm privileged.
Women power, so as she said.
Congratulations, it was a really nice talk.
Thank you so much.
Thank you so much, Dr. Gafili and Debolina.